Welcome to the latest episode of Risk Settlements Podcast, Alternative Litigation Strategies, where I interview esteemed members of the bar on the latest trends and developments in the world of class action and other types of commercial litigation. I'm your host, Kevin Skrzysowski, with the litigation consulting firm Risk Settlements. And today we'll be discussing a response plan of what to do after being served with a class action lawsuit. I'm pleased to be joined by David Yeagley, a partner and trial lawyer with the law firm of Ulmer and Berne in my hometown of Cleveland, Ohio. David, good morning, and thank you for being on the program.
Kevin, good morning. Good to be with you today.
Wonderful. David, I am really excited to discuss this topic since one of the core competencies of our business is working with clients who are defending active litigation and helping them to design and actually also ensure settlement structures. But before we get into a recent article that you wrote, perhaps you can tell us a little bit about your career, your practice, and the types of matters that you litigate.
Sure. Thanks, Kevin. Well, I've been a class action litigator for over 30 years now. And interestingly enough, I've been on both sides. I spent the first 10 or 12 years of my career on the plaintiff's side, and then switched over primarily to the defense side. And so I've seen both sides of the class action and think that I probably have a pretty good insight into what the other side is thinking in terms of be it either the prosecuting the class action or defending it. And aside from class actions, I have a pretty broad commercial practice involving consumer claims, warranty, real estate, construction matters, contracts, and other largely non-injury types of disputes.
Very interesting. And I think having a background as both plaintiff's counsel and defense counsel does give you a really unique, objective way to look at litigation. Ironically, it's similar to how we built out our team. We're a collection of former plaintiff lawyers, defense lawyers, insurance professionals, and investment bankers. And so we've created a unique system of processes to evaluate class action litigation. I think that's very interesting. Now, I understand you had a post-pandemic jury trial recently in the Northern District of Illinois. Was that the first bench trial you've had since we shut down from COVID?
It was actually a jury trial. I think it was the first one that our judge in the Northern District of Illinois had civil trial, at least, since the pandemic. And it was a very interesting process. There were some changes that were made in how the case, in sort of the courtroom procedures, if you will. But overall, it didn't seem to be that remarkably different. Tried it to verdict, and it was a great experience.
Sounds very interesting, and congratulations on that. So it sounds like from what I'm hearing from you and from what we're seeing and from all the other lawyers we work with, everybody is back to business, and there has really been a flurry of litigation moving across people's desks, both from newly filed cases and a lot of cases that were moving at a snail's pace over the past 2 years. So we're all back in the saddle. Now, you recently wrote an article that was featured in JD Supra titled, "A Class Action Was Filed, Now What? A 10-point response plan." Did you have any particular motivation behind writing this article? Was there some type of real life event that perhaps triggered your thought to put pen to paper and share your guidance with the market?
Well, just as a general matter, I'd like to write sometimes on specific case matters or specific aspects of litigation. In this particular instance, I think I was thinking about some recent cases that were filed and what would I do and what would our team do if we were retained to handle the case. So I think that was the genesis of the article.
Okay, that makes sense. I want to go through your 10-point response plan, but first, operating in the world of class action on a daily basis, it's a very unique animal, and there are a lot of differences from more traditional B2B commercial litigation. Would you agree with that?
Yeah, absolutely. I think one of the first things that stands out is the fact that there's aggregate liability. And so the stakes are always higher in a class action. And I think there are lots of other unique aspects to a class action. It's a representative litigation vehicle, if you will. And so there's just a lot of moving pieces associated with the defense. I think another aspect of it that makes a class action unique is just the fact that the trial court has wide discretion in terms of applying the Rule 23 prerequisites and how the case proceeds. And I suppose the final aspect of it is often these class actions are very lawyer driven. And so they're not so much about an injury or something like that, a typical run of the mill, if you will, if there's any such thing, case. It's really oftentimes a case that's driven from the commencement through the final disposition by lawyers.
I couldn't agree with you more. I think that you are spot on with all of your points. So let's take a look at your plan after you're served with a class action lawsuit. So let's go top down. Doing the initial case assessment. So there's a lot of considerations that go into that. Can you take us through them?
Absolutely. The first thing you have to understand is what's really at issue in this case. What is the claim, the heart of the claim, and what are the facts that are going to drive that claim? And that requires a quick, rapid investigation and analysis, working with the client, interviewing key individuals, witnesses, if you will, and really getting your arms around what the theory is and developing, I would say, a working or preliminary defense theory so that you can understand what the case is and start to formulate your plan for defending it. These considerations need to evolve often very quickly for reasons that may include initial motion practice and also choosing which court you're going to commence your defense of the case.
So you do your claims analysis, you start working on the defense, you're moving at a very quick operational tempo. Most people next are thinking about coverage. Do we have coverage? So I would assume that right after the claims analysis, you start thinking about, let's investigate the insurance coverage. Let's put the insurers on notice. And also take us through the types of cases where there is coverage. And sometimes, as we see in our business, types of cases where there isn't coverage or there isn't an inadequate amount to cover the full potential liability.
Sure. So obviously, in many cases, there isn't going to be any coverage or any real viable coverage that may be different. In some cases, particularly class actions in the pharmaceutical space, is in my experience. But that's a critical consideration for the company and for general counsel of the company. So we work through those issues. Obviously, it bears mentioning the litigation hold and making sure that everything, the ESI and everything is locked down. But one of the critical things is getting the insurer on notice and figuring out if there's coverage.
Right. And I think you hit on a very valid point as well, which is making sure that you determine if there's coverage, but then also they're putting the proper amount into escrow. And as I think we'll get into a little bit later, that can have detrimental effects on just running business operations. And clients are always looking for alternative ways to mitigate those holds and mitigate those risks. So, okay, we've done our claims analysis. We've looked at coverage. We've discussed escrow. Let's move on to jurisdiction. What considerations go into determining if a case should be in state or federal court? And what are the pros and cons of each?
That's an important analysis. I will tell you from the defense perspective, almost all companies would prefer to defend in federal court. And CAFA, of course, the Class Action Fairness Act, makes that much easier in the last 15 or so years of getting at least a bigger case into federal court. So I think most counsel are rightly cautious in terms of overriding the presumption of taking a case to federal court and keeping it in state court because, you own it after that. You own that decision. So in general, bigger cases are largely going to end up in federal court. There are advantages of that. Of course, the federal courts are generally have more staffing in terms of really capable law clerks who will devote considerable time to the case and to motion practice. The common perception is that preliminary motions, like motions to dismiss, are given a more detailed hearing in federal court. There may be a more receptive audience to a motion to strike, depending on the circuit and the judge. That's a motion to strike the class action allegations. So those are all relevant considerations in getting a case to federal court. Of course, that requires prompt action, going back to the initial case assessment, in terms of figuring out what you need to establish if you're removing the case, if the defendant is removing the case, figuring out what you need to bear the burden of establishing the amount in controversy. And that can be difficult depending on the case and the allegations of the complaint. And so that's a critical initial step that has to be executed in really a matter of a few weeks.
And I think those are all good points for bringing a case in federal court. Specific question just regards to settlements for you, though. Have you ever found, though, that it sometimes is just more efficient to get a class-wide settlement approved in state court because there isn't the CAFA requirements and perhaps there's less scrutiny from potential objectors?
That's true. And that's an excellent point. Another point about state court is, at least in Ohio and other state courts, there's an immediate interlocutory appeal on the ruling on class certification, which can be an important escape hatch. Of course, you don't have that in federal court. You have potential discretionary appeal under Rule 23F, but that's not the same thing. And some circuits are really tough in terms of accepting discretionary interlocutory appeals. So there are certainly settlement advantages in state court typically versus federal court. There's also some other advantages in maintaining a case in state court. Again, I always think of it as a situation where if the facts and law of the case are driving a quick settlement because perhaps it's a bad situation or perhaps it's going to be a very minor settlement below the cost of defense, for instance, and the company is willing to engage in the process, then you might decide to stay in state court and not remove a case to federal court.
It sounds like there are many different considerations to consider for each jurisdiction based upon a host of factors, the type of case, the size of case, the potential exposure. So very critical. I definitely understand that there's a very critical analysis that goes into that, the portion of deciding jurisdiction and whether or not you're in the right court. Let's move back into the defense plan and building out the larger defense plan. But what I actually wanted to ask you, which I probably should have asked you at the beginning, once a company is served with the class action lawsuit, some of the criteria that go into them deciding what law firm to select and what lawyer to select. So let me ask you personally, what are some of the strategies that you employ to win your client's business and separate you from the rest of the pack?
I think it boils down to a vision for the defense, a plan on how you're going to win the case. And that includes an analysis of each of you might think of them as pressure points along the way. What is the motion to dismiss going to look like? Is there a viable motion to strike the class action allegations, knowing that that's not the right move in every case? And then what is it about the case and the facts that are going to create a compelling case to defend class certification? I really look at the defense of class certification as not pointing out the flaws in the plaintiff's theory or their facts, but in actually building out, if you will, the defense as if you bear the burden of proving that a class action is impossible based upon the facts, the elements of the claims, and so have in the damages theories, whatever the particular circumstances of that case might be.
I think that's a great approach. And so going into the defense plan, you had mentioned the motion to dismiss. We've spoken with different lawyers about their philosophies behind whether to file or not to file. What considerations go into developing a motion to dismiss? And have you had instances where you don't necessarily want to file one because you don't want to put all of your cards on the table at that phase, and perhaps you're waiting for a later phase, such as motion for summary judgment or the certification phase?
Right. Those are all really critical decision points along the way. My experience and approach is to not hold back much, because in a class action, my view is you take every valid issue, not the crazy procedural ones that don't really matter, but every valid issue is defended because you don't know where your break is going to be. And so I think it's difficult in a class action to hold off on arguments, particularly ones that can't be fixed, if you will, by the plaintiffs, but to hold off and hold back in anticipation of later motion practice. Because if you don't prevail on a motion to dismiss, then the next step in the case, really probably the next step in the case, is defend class certification. Then you're facing the prospect of aggregate liability, notice, and lots of unpleasant procedures, as well as lengthy process of discovery before you even get to class certification. So my view is not to pull many, or if any, punches at the motion to dismiss and go hard right from the outset. Focusing, of course, as you always would, on the weaknesses in the plaintiff's case, on claims that involve fee shifting or expanded damages, things like that, trying to take away the plaintiff's leverage in the case.
And I think that makes sense, vigorous defense from the beginning. And then you had mentioned discovery next. Let's move on to discovery. So, of course, that can be the most expensive and the most time-consuming portion of litigation. So, this question may be a little bit rhetorical in nature, but in your article, you had mentioned filing a motion to stay discovery while a motion to dismiss is pending. Are there any other considerations in doing so other than to just not have the increase of additional financial costs of discovery?
Well, I think the other one might be more a perception, and that is, if you've just filed a motion to dismiss that'll stop the case dead in its tracks, we really don't want the perception from the defense side that the case is moving forward. And so I think that's part of a motion to dismiss. And I think a general observation here is that there's nothing that's more disproportionate, if you will, than discovery in a class action. You get 10 pieces of paper from the plaintiff and potentially hundreds of thousands of pages of documents from the defendant. And so there's nothing, there's no level playing field, if you will, in the discovery process. And it's just inordinately expensive, burdensome, and it's really a one-way street in terms of the burden on the defendant.
It really is, isn't it? I know when we're collecting data to do our risk modeling and analysis and underwriting on settlement structures, very little is provided from plaintiff's counsel or if class is certified class counsel. But when we're looking at data to do our modeling and we're looking at call records or fax records in TCPA cases or sales record and records from food and beverage mislabeling cases. The files are so huge they can't even be transmitted electronically. And you're looking through hundreds of thousands of rows of data. It is very, very data intensive, and you raise a very good point.
I think, if I might add, though, discovery with respect to the plaintiff, both from the plaintiff and internally in terms of the company's own records and experience, is still important, though. And it's amazing to me how many times counsel for the plaintiffs eager to file a class action picks a bad plaintiff, picks a plaintiff that is subject to unique defenses, right, or that really doesn't have the claim that's being asserted. It happens more than you could possibly imagine. And so I would want to highlight the fact that discovery and investigation as the plaintiff's claim is still important.
No, thank you. That's a very good point. I'm glad that you raised that. So sticking with discovery and moving into identification of experts, there's several different types of experts that you need to identify in order to ensure that you have a thorough defense. What are the different types of experts that you look to retain when you're helping out one of your clients defend a class action litigation?
Sure. We all know about the liability experts and subject matter experts and what have you. But in a class action, you have to consider and use experts at the class certification stage. And so really what I would be focusing on depends on the circumstances of the case, but you're really looking at expert testimony that goes to the issue of class-wide proof, and specifically the inability to provide class-wide proof, both as of liability and damages. Of course, not the amount of damages so much, but different damages theories, or the fact that the class is overbroad and that a significant number of the individuals encompassed within a purported class simply don't have any injury and don't have any claim. So I'm really focusing on predominance, perhaps on the ascertainability of the class from the outset as well. I think those are the critical experts that you would use on class certification. Again, subject matter experts, depending on the nature and circumstances of the case.
Sure, because it goes towards defeating class certification or mitigating the potential exposure. So I think all that makes perfect sense. So now you've identified several experts in your case, and now there's a lot of parties involved. There's a lot of people involved. You have, I would imagine, your defense team, then plaintiff's counsel has their team. You have this group of experts that you've identified. You probably have a team of representatives from the company that you're reporting into. There's all these different moving pieces, as there is with any large commercial litigation. So, I'm assuming that there are internal and external communication lines that you have to establish both with your client and with opposing counsel. And I think maintaining those proper communication lines and having a plan in place for who takes the lead and who's really captain of the ship and controls the communication is important. Take us through what your ideas of a proper communications plan are.
Sure. I think it's important to have someone from the company that is responsible for communications. In terms of reporting on status and developments in the case, that may be a broader line of communication. But in terms of just tracking down witnesses, conducting internal interviews, finding information that you need, and what have you, I think it's important that there's a point person at the company that can handle some of that. I think it's important, not just in terms of developing facts, to interview witnesses with the company, but also to start planting the seeds, to do some early deposition prep, if you will, in terms of educating the potential witnesses of what the case is about and the facts so that they can provide their best testimony, ultimately, assuming that they're going to be called as witnesses in the discovery phase. But so I think those kinds of communications with the client and the point person are critical to an efficient defense and a full comprehensive defense. Oftentimes, when witnesses understand the nature, company, employees understand the nature of the case and how it's to be defended, they know facts. They can relate facts that you would otherwise have a very difficult time sort of extracting without their assistance. And so I think client education is a big part of a comprehensive defense plan. And then on the flip side, I think it's important to your client to have decent relations with opposing counsel. And there's just no point to fighting over silly things. It detracts from your case, whether it's plaintiff or defendant. It annoys the judge, rightly so. And so I think that's another part of the case that's important to develop.
Yeah, I think you raise a very good point. I know in our business, we're normally brought in when the parties want to achieve a settlement and they're heading into a mediation. So you're always dealing with a tough opponent and a tough litigator. But when they are a rational, legal, and economic thinker, it's always the best mindset to have to be able to meet in the middle and achieve an efficient resolution on both sides. So you raise an excellent point. Moving on to exit strategies, the question I've been waiting to ask you the most, since this is I live, eat, and breathe settling class action cases on a daily basis. So besides motion practice, what are some creative litigation or settlement strategies that you employ or that you leverage for businesses you're defending when you're considering the implication of settlement versus further litigation?
Sure. Well, that is, of course, as defense counsel, that's your task, is to end this in some way that's favorable for the company. And so one of the ways that has to be considered is a settlement of the case. And there are various ways that can take, and we can discuss those ways. But certainly as someone who's defended many, many class actions, I've run endless spreadsheet scenarios of claims, tiered claims, claim rates, and what happens in order to evaluate the structure. I'm a proponent of claims-made settlements versus common fund settlements. I think the common fund settlements they're easy in terms of being a lump sum number, but oftentimes I think they're not most advantageous to the company. And so in terms of claims-made settlements, one of the things that's fascinating now, of course, is the ability to cap the risk of the companies, because they are tremendously interested in this sort of unknown variable in claims rates and how that's going to go. It's perhaps easy to compute maximum exposure, but that's often unrealistic or almost always unrealistic. And so really, I think that's where, Kevin, your insurance product comes in and really gives a tool for defense counsel and the companies to consider.
No, and thank you, David. I think you're spot on, and thank you for the plug. I think the points you raise about claims made versus a common fund are terrific. And I know we always say it's a way to ensure that everybody in the class who opts in gets the same benefit as opposed to a common fund. If the claims are very low, then the people who do file a claim could almost be unjustly enriched. But if the claims are very high, then they're really getting a de minimis award. And so through a claims made process, you're able to remove that and provide something that's equal to everybody who opts in. The only issue with that, to your point, is you never really know what the ultimate payout would be. And so we designed a litigation risk transfer vehicle called class action settlement insurance, which basically transfers all of the financial risk in claims made settlements away from defending businesses to an insurance carrier in exchange for a one-time payment of premium. And what it does is it mitigates caps and transfers, that unknown risk. But most importantly to companies, it's a way for them to exit litigation with absolute cost certainty and mitigate their balance sheet and their P&L impairment, which we talked about at the beginning in terms of you're establishing your litigation reserves. So it's a great tool to cost effectively and cost efficiently, exit litigation. And that certainty is so highly valued by all of the companies that we worked with.
Well, certainly as someone who's, as I said, run those endless spreadsheet scenarios in terms of claims made and then tried to answer questions, valid, legitimate questions about what claims experience is likely to be and layering all those disclaimers and what have you on them. The ability to deliver certainty is really a valuable concept. So I look forward to using that in the future.
That's terrific. And it's true that you really never know where those claims are going to come in. We've seen a lot of cases in recent years go viral during COVID. And when everybody was sheltered in place, we saw a significant uptick in the ultimate payouts. And then, of course, if you're doing a publication notice, I know, food and beverage mislabeling cases have been proliferating in recent years. They're a huge part of our docket. You do publication notice, and a lot of times it gets picked up on all these feeder websites or social media. I mean, my middle school children even showed me TikTokers with hundreds of thousands of followers who are advocating filing a claim against a certain food product that is popular amongst teens. And that really makes your claims go viral. So I know a lot of businesses are looking for a solution like settlement insurance that can cap that risk. So
it's a new world out there.
Oh, it is. It really is.
Absolutely. Of course, not every case filed as a class action is appropriate for a class action settlement. And I think in Bear's discussion in terms of using other possible means to exit a case, I've used, and particularly in pandemic, where lawyers have been cautious, I think, in investing lots of time, of their own time, in cases with questionable results. We've been successful using Rule 408 disclosures in terms of really sort of giving insight into valuable financial information or liability defenses. And sort of I go back then and wear my plaintiff's hat and actually have a discussion with opposing counsel and say, based on my experience, I think this is what you're worried about, and we're willing to show you this information. And I think it's going to have an effect on whether you think there's really any reward at the end of a long, arduous case where you're going to invest a lot of time and money. And so we've been successful in just ending class actions based on individual settlements with using those disclosures.
No, I think that is, if you can settle with the named plaintiff, that is an efficient, probably the most cost efficient way to settle. if you can, and if you can avoid that nationwide liability and exposure, and you're not looking for that full release. But your point about 4.8 disclosures is also a very valid one. And it goes back to your other point about having your open lines of communication with the opposing counsel and trying to work together towards a resolution. So last but not least, the 10th point of your response plan to defending a class action litigation: collateral risks. So what are the collateral risks that you have to be cautious of? And David, how do you protect your clients from them?
Well, it sometimes is difficult, but certainly some of the collateral risks could be regulatory action, attorney general interest in the cases. There's obviously multi-state attorney general organizations that can become interested in cases and settlements in the right circumstances. And so I think there's a minefield there that sometimes has to be navigated. There may be revisions to documents or practices that should be undertaken to address regulatory or future litigation risk, maybe even accruing damages. So I think that's among the things to think about in terms of, is this just an isolated class action, or is this something that could go beyond that?
So again, many, many critical factors to consider. Well, that takes us through the 10-point response plan. David, I really want to thank you for your detailed and your incredibly insightful and valuable thoughts that you've shared with me today and shared with our audience today. As a conclusion, do you have any final comments or perhaps any advice for young lawyers who are getting started in law or commercial or class action litigation?
Well, thanks, Kevin. This has been a real fun experience, and I've enjoyed this very much. I think I'll take you up on both of those things. Just for newer lawyers, particularly in the sphere of complex litigation, where there's maybe not a recipe for defending the case. It's a newer theory or some unique facts, a one-off, if you will. Those are really the fun and rewarding cases, in my view. But my advice, one of the major pieces of advice I would have for new lawyers is don't necessarily try to answer questions as much as understand the reasons, the underlying jurisprudential reasons for why the judge should decide a particular issue one way. I think that's critical to developing a comprehensive defense and really to identifying additional reasons or theories to assist, be it in the defense or the prosecution of the case. So I think there's really a deeper understanding of why the law is what it is on that particular issue is something that I would encourage younger lawyers to do. It's maybe a little harder now that we use search terms than it was back when I started, when we were reading cases and extracting, rationales and holdings. So that's one of my, given a long history here, litigation, maybe that's one of my observations for whatever it's worth.
I think that is great advice. And for all of the younger lawyers and newer members of the bar who are listeners, I hope they tune in and they take heed. So if anyone would like to contact you directly to discuss any of the topics that we've covered here today, what would be the best way to reach you?
I can be found pretty easily. I'm a lawyer here at Ulmer and Berne in Cleveland, and my email is Yeagley, Dyeagley at Ulmer, ULMER.com. My direct dial is 216-583-7216. And I would love to hear from any listeners and be happy to discuss any aspects of our conversation. Again, it's been fun, and thanks for having me today, Kevin. Appreciate it.
David, you're quite welcome, and thank you again for joining me today. I would also like to thank our audience for listening. If you'd like to hear more, please be sure to follow us on Apple, Spotify, or anywhere you listen to your favorite podcasts. If you'd like to listen to a recording of today's program or to learn more about our litigation and settlement risk transfer solutions, including class action settlement insurance that is available for a wide array of different types of class action litigation, please visit the Risk Settlements website at www.risksettlements.com. And of course, you can always reach me directly at kevins@risksettlements.com or my direct dial 216-570-9370. David, thank you again, and thank you everyone for listening.
Thanks.